Thank you all for being here. As we were trying to figure out how to commemorate this 50th anniversary of the Washburn Law Journal, we knew we wanted to do something different. I remember meeting with Dean Romig, and his words were, "Think big." So thank you, Dean Romig, for allowing us to think big and have this tonight. So the next thing we did is we spent some time trying to identify who we thought would be the good keynote speaker for this occasion. Eventually, we kept coming back to the idea that the story of the Washburn Law Journal is best told by those who lived it. So that's what we're going to do here. In the spirit of the first editor's note, entitled Obiter Dictum in 1960, which is Latin for remarks by the way, we've invited 6 former editors to give their own remarks by the way of their experience with the Washburn Law Journal and its 50-year history. At the back table, our newest edition of the Washburn Law Journal, issue 2, volume 50, just came from the publisher a couple days ago. Then there's a history of the early years of the Washburn Law Journal that Professor Jim Concannon was gracious to do for us. As we went through that history, we learned a lot of things. The history can be traced down back to 1932. Student submissions were given to the Journal of the Bar Association of Kansas. A few highlights that we found in there. In 1947, a Washburn student named Joseph W. Morris had the rare distinction of writing the lead article in the KBA Journal. That student, Judge Joseph Morris, is here tonight. In 1948, the school started naming a student to be editor-in-chief. In 1953, the school started internal talks about creating its own student-run law review. In 1959, 1960, Robert Roberts and David Wheeler were editors of an intramural journal, which is also back there, labeled Volume 0 of the Washburn Law Journal, distributed within the school. It was kind of a tryout to see how it would go. So then in the spring of 1960, faculty member Walter Navin offered our first speaker $500 a semester to be the editor-in-chief of the first professionally printed Washburn Law Journal. And that's how we got started. After graduation, our first speaker served in the Air Force JAG for 3 years and then joined his father to form Hahn and Hahn in Phillipsburg, Kansas from 1964 to 2004. Along the way, he was the Phillips County Attorney, a member of the Kansas Supreme Court Nominating Commission, a member of the Board of Governors for the Law School Alumni Association, and currently he serves as a member of the Washburn University Foundation Board of Trustees. It is my honor to introduce to you the editor-in-chief of Volume 1 of the Washburn Law Journal, Mr. Lowell Hahn.
Thank you, Larry. I'd like to begin by introducing to you my spouse of 52 years. She's sneaking over there. She's also an Ichabod who received her BA in education in 1960, and she got another degree in 1961. It was politically incorrectly called PHT, or Putting Hubby Through. Should be probably called Putting Spouses Through now, but we had no women in our class of 1961. Thank you, Carl, for all you do for me and our family. President Farley, Dean Romig, faculty members present and past, judges of our courts, editors and staff of the Washburn Law Journal, and distinguished guests. It is a singular honor and privilege for me to share with you this unique evening, a significant milestone in the journal's long and distinguished history. 50 years ago, the board held the first honors banquet at the old Kansan Hotel, I believe it was, in downtown Topeka. And I know that none of us ever dreamed of even being here. Professor Arns would have called that being in the circle of foreseeability. Editor Eric, on behalf of the 15 board members 15, who put out that first law journal. Thank you for your efforts and the efforts of your staff to both assemble a 50th edition and arrange this special event. I thought this group, and especially 44, Eric, is it, members of the President's staff, 3 times as many. Those of you who can look forward to another 50 years, the 100th anniversary in 2061, might be interested in the destinies of the 15 men that are listed on the masthead of Volume 1. To my best knowledge, 3 and perhaps 4, I asked Art and he wasn't sure, members are deceased, as is Professor Navin, our faculty advisor. Another is in a care home. 1 didn't complete school. 1 went to California and made a fortune, not in law, in real estate, so I'm told. 2 became district judges. Another, a federal administrative law judge, after a long career with the IRS. And those 3 fellows and I, after speaking together, have no clue as to what happened to 3 of the people. The remainder entered into private practice in specialized areas, 1 in bankruptcy law and another in trial practice in Wichita. And finally, after serving Dean Romig in the Air Force, Jay, in a far north outpost in the Upper Peninsula of Michigan. It was lots of fun. I came back home to western Kansas and became a country lawyer in the true sense of the word, a general practitioner, where my specialty was knowing what not to get involved in. I can remember associating several times with my good friend Art Palmer because I didn't want to get involved. So, how do 15 law students create a law journal? The word today, I suppose, is startup. How do we had a typewriter or 2. We had no computers. We had no faxes. We had no cell phones. We had a mimeograph. That's how the first one was. Volume 0 was put up. Where do you begin? With the name? What about the cover? Where would the articles come from? We didn't know any of that. The board began by examining other law reviews and journals and took from them the best ideas of what we thought we wanted. We decided the cover should be distinctly Washburn, and so determined it would be blue and white, Washburn's colors. And since there were lots of reviews, or so it seemed, and the board wanted the publication to stand apart, we decided to call it a journal rather than a law review. Journal versus review. Somehow the law school found sufficient funds to send me and Art and a couple of other people, along with Professor Navin, to the National Conference of Law Reviews in Madison, Wisconsin, at the university there. And I know that we learned an awful lot about those questions that we were trying to answer. But tonight, my sole specific recollection of that conference is this: the student union in 1960 could serve beer. Can you believe that? Bart and I couldn't believe that either. Yeah, you know, the guys from Kansas that served beer in the student union came as a real shock to us. We located a printer by the name of Steves and Company, or Steves and Son, something like that. They were on the west side of Kansas Avenue, south of 10th Street. And with their help, we picked out a typeface and style. I made many trips to that location with galley proofs. Now, nobody here, Art, knows what galley proofs are. That's what the printer puts on top of the linotype that is set in lead. And we would take those back and forth. We also, most importantly, I think, decided that all articles, regardless of the author, student or otherwise, would be required to conform to the Blue Book legal citation rules and to the requirements of proper English grammar. That caused some problems once in a while. I can remember some grumbling from students who articles had been submitted for publication and came back all marked up in red, and they didn't like that too much. Dean Howe agreed to prepare for Volume 1, Number 1, a report to the bar, and we hope it would be an annual thing. And a great friend of Washburn Law School, Collier John Chambers of Kansas City, agreed to adapt a paper on discovery depositions, which we're just getting started in, for the same issue. But we had a problem. John was so busy and so good at what he did that he never could seem to get the article adapted. And so finally, after several telephone conversations, I drove to his office in Kansas City, picked up the article, and got it back in time for publication. Today, of course, we fax it back and forth, or email it back and forth. We continued to tinker with the product for issue 2, and finally we settled upon an order which basically is what it is yet today. And we decided that the editor would be required to, in addition to a note, write an editor's call. And so I searched around and thought about what hi from the editor, or what, and somehow came across obiter dictum, which means, as you all know, remarks by the way. And that's where we discussed. From then, for 32 issues, Eric told me, it was called obiter dictum, and the article and the editor could talk about what was going to be in that issue. What did I learn from my experience? Did it really impact my practice of law in far northwest Kansas? Absolutely, positively, yes, it did. And I think much for the better. I know my pleadings and my motion writings were better, I know my appellate briefs were better. And those briefs, I can assure you, were always meticulously blue booked. And I think grammatically correct. And I assure you of that for one simple reason. I knew an awful lot of the judges that those briefs were going to go to. And I wasn't about to have them call me up and say, guess what? You misspelled a word, or it shouldn't have been cited that way. So I was very careful about that. I received a bound volume from Professor Navin with issues 1 and 2. And he wrote in it upside down. But that doesn't matter. I look at it and compare it with what is the publication today, and it is just astonishing. And it makes me so proud and thrilled with all the work that those 15 guys did in getting this off the ground. The journal today is, without a doubt, an outstanding legal publication, one which all connected to it can be justly proud. I know I am. Thank you.